Yeah, click record.
Okay, and I do see
Now
it.
it's recording. There you go. You got
We
it.
are live. Okay, this is going to be a really good webinar. Unfortunately, I know usually you should introduce yourself as the host. I think everyone here on the call is familiar with me, but I'm still going to do that for maybe those who watch the recording. This is your host, Ali Taj Bey. We are here today. We're discussing the trust funds and the trust that most judges and officials tell us that doesn't exist. So I'm here to actually be the contradiction to that today. So this is some of the juicy stuff that I found for you. This is the letter of transmittal from the Board of Trustees of the Federal Old Age and Survivors Insurance, which is a very important word, and Federal Disability Insurance. And then we have trust funds. This is out of Washington, D.C. And I want you to see some of the signers on this. So it says, we have the honor of transmitting to you the 2019 annual report of the Board of Trustees. So this lets us know that there are trusts. We're not crazy. They do exist. Of the Federal Old Age and Survivors Insurance and Federal Disability Insurance Trust Funds, the 79th such report, respectfully, Stephen T. Mnuchin, Secretary of the Treasury. That's what those funds are. And managing trustee of the trust funds. So, you know, we're not as crazy as they make us out to be. This is real. And as you see, it's wet ink. R. Alexander Acosta, Secretary of Labor and Trustee. I spoke about this before on a live. This system is propped up by our actual labor. And that's why the Department of Labor is so important. So this is the Secretary of Labor right alongside Stephen Mnuchin, who's the Secretary of Treasury. And he's also a trustee. Then you have Alex Azar, Secretary of Health and Human Services. So, you know, again, they're talking about us. You have Nancy A. Berryhill, Acting Commissioner of Social Security, and she's also a trustee for the Social Security, which lets you know, yes, it is a trust fund. Here we have 2 vacant spots for the trustees that haven't been filled, and they're saying that's why a lot of our discharges that have been being sent to the Treasury have not been being taken care of, because a lot of these slots actually right now are vacant, and that's what's let us know that we're going under a reorganization and a currency reset. We're currently in the eye of that right now. And this is the Deputy Commissioner of Social Security right here, and Acting Secretary for the Board of Trustees. So this is a very long report. I think, let me see if I can put this in the chat for you guys if you want to go ahead and grab this for yourselves. So go over here. All right. All right, not as easy as I thought. I thought that was the chat right there. Trying to drop this in the chat for you guys. Okay, here we go. All right, so that PDF is in the chat for you. Let's continue. All right, so we got that. There was something else that I wanted to show you here on the trust funds. I'm trying to remember if it was. Okay, so this is very important. I found this a while ago and I had a couple screenshots, which I can't find, but I did my best to find it again. Because of the 2 public trustees positions are currently vacant, there is no message from the public trustees for inclusion in the summary of the 2020 annual reports. So letting you know those offices are now vacant. Who are the trustees? There are 6 trustees, 4 of whom serve by virtue of their positions in the federal government: the Secretary of Treasury, the Secretary of Labor, the Secretary of Health and Human Services, and the Commissioner of Social Security. The other 2 trustees are public representatives appointed by the President. So that would be number 45. Subject to confirmation by the Senate, the 2 public trustee positions have been vacant since July 2015. Look at that. All right, so we're gonna go back up to the top because I think there was something I wanted to show you here. And I think it was just this, but we already found that again in the other PDF there. So just gonna keep moving around. I just wanna move this out the way. And this, well, all right, maybe I'll go, where's that other one? All right, I'm gonna go here first. So basically we were talking that the certificate of live birth and the Social Security account number all have credit in it. They all have credits. So this is the proof. A lot of this is about not just making claims, but about having the proof to back it up. So of course, Title 11 is your bankruptcy code. And just after, I guess maybe the last month or so of me being in this bankruptcy code, helping others, I was able to figure out that this is actually where we belong. We're supposed to be here because what happens in bankruptcy is the trustees are there, they're already working for you. And not only are they working for you, but the fact that there are trustees means that there is a trust. And of course, they may call you debtor and they throw you off a lot by that. But if you're there in bankruptcy and you went knocking on that door, of course, you're the beneficiary in the bankruptcy proceedings, which ends up in liquidation. Liquidation is synonymous with settlement. They will settle all your debts. And a lot of people speak about getting discharged, or I'm going to discharge some debt because we know we can't pay it. But the bankruptcy court between the trustee and the court has the power to discharge all your debts. So I want you to see some of the powers that the trustee has. So obtaining credit. If the trustee is authorized to operate the business of the debtor, and this is why everybody here is on this call, because I wanted to get some advanced people who I wouldn't have to stop every second and break this down. We do know that the estate is a business. So to someone else, maybe this might have went over their head or they might not have understood exactly what was being said. But the trustee is authorized to operate the business of the debtor. Our business is our estate. Unless the court orders otherwise, the trustee may obtain unsecured credit. You don't need any collateral. He can go and get unsecured credit on our behalf and incur unsecured debt in the ordinary course of business allowable under Section 503B1 of this title as an administrative expense. The court, after notice and a hearing, may authorize the trustee to obtain unsecured credit or to incur unsecured debt other than under subsection A of this section allowable under Section 503B1 of this title as an administrative expense. If the trustee is unable to obtain unsecured credit allowable under Section 503B1 of this title as an administrative expense, the court, after notice and a hearing, may authorize the obtaining of credit or the incurring of debt. And that's why it was so important who I showed you who the trustees were, because the bankruptcy trustees are under the United States Trustee Office. So it's definitely a branch of that. And this is where Stephen Mnuchin and everybody else falls under. It says with priority over any and all administrative expenses to the kind specified in Section 503B or 507B of this title, secured by a lien on property of the estate that is not otherwise subject to a lien, or secured by a junior lien on property of the estate that is subject to a lien. So this is something else I guess I'm going to put in the chat for you. This was this is really important right here. Let me see. Subsection F, except with respect to an entity that is an underwriter as defined in Section 1145B of this title, Section 5 of the Securities Act of 1933, the Trust Indenture Act of 1939. So again, this is admitting right here, we already knew that there's trustees available so that there is a trust. And that's where this falls in. And we know that we're dealing in securities when we see the word credit. And any state or local law requiring registration for offer or sale of a security, or registration or licensing of an issuer of, underwriter of, or broker or dealer in a security does not apply to the offer or sale under this section of a security that is not an equity security. So that was a really powerful find. I think I just found that, might have been 2 days ago, to just make sense of what we were doing in the process, instead of just speculating. There's so much speculating when people are teaching. We're just saying things and say, well, it makes sense, but we don't come with the proof. So that was important, that I wanted to go and get proof of what we were actually talking about and discussing. So oh, sorry about that. And trying to make sure there was something. Okay, so this is where we're going to go. Being that I've just showed that the credit is ours, the trust is ours, we're the beneficiary, the credit belongs to us. This is what I wanted to show you. So now that we know our role and know who we are, we have the power to bring businesses into bankruptcy court for them not settling our debts for us. They take our instrument and they don't give us any credit, and we're stuck paying the bill. So I want to show you the power that we have to come into bankruptcy as the creditor. So we drag them in there. This is called the involuntary petition for bankruptcy. The name of debtor, and this you would have to do individually for each debtor you're bringing. This is not an action you can name multiple debtors on. So the name of the debtor would be your lien holder or whoever is servicing your account. I don't know if I would do this for something small. I definitely, if you're doing it for a vehicle, maybe a luxury vehicle, it's 38,000 or higher, it's 100,000. I definitely would do it. If this is a house you're talking about, I would definitely drag them in there under involuntary petition. So this, you would get their tax ID or EIN number, put this here. This is their address, which you would look up on the state of incorporation, wherever they're incorporated. You would use that. This would be their mailing address. So this is the person that you would, who's their registered agent of service. You would put that address there. This is all the principal place of business. You can be found on their filing with the Secretary of State. So location of principal assets of business, if it's different from what's listed above. Most likely you could do, for a business, it's supposed to be chapter 11. I think it could be 11 or 7, but 7 is liquidation, is what you want to liquidate their assets. The debts, so you would be the petitioner in this situation. Debts are primarily consumer debts. You would put that down. Type of debtor, more likely it'd be a corporation or a partnership if it's a law firm. Nature of business, so you would probably put stockbroker. You could put commodity broker or clearing bank. Any one of those would do. So the venue, debtor has been domiciled or has a residence, principal place of business, or principal assets in the district for 180 days immediately preceding the date of this petition. So this is where you would fill that out. Filing fee, petitioner, let me see. If you want, like I said, if you're dealing with a big purchase, a really expensive car or a house, just go ahead and pay the filing fee. Or there's also a fee waiver form that you can file in the bankruptcy court. Pending bankruptcy case filed by or against any partner, no, so probably wouldn't need that. Allegations. Petitioners are eligible to file this petition under, and this is 303. The debtor is a person against whom an order for relief may be entered under Title 11 of the state's code. That's why I said above, I think it would be a Chapter 11. The debtor is generally, so this would apply to, generally not paying such debtors' debts as they become due unless such debts are the subject of bona fide dispute as to liability or amount. So that would definitely be checked here. And let me see. So it could be, I'm gonna say check all eligible. So it'd probably be that one and that one. And this is where you get into the claims and request for relief of what you want done. And you're going to do this under penalty of perjury, which makes this ironclad and powerful. And if they're going to dispute your claim, they're going to have to come in and do the same thing, penalty of perjury. So you would sign all this, address it, signing in representative capacity. So like I said, this is why I brought you guys in, because you're experienced enough to understand this without me going through it. We know that we have to sign by, last name, first name, comma, or authorized representative or beneficiary of a state or something like that. We have to sign in a capacity. So, and this is where we will list ourselves. We are the petitioning creditors because we extended the credit that was stolen from us. So you would do nature of claim, amount of claim. The amount of claim would be the amount of the instrument. If you bought a house, it was $360,000. That would be the amount of the claim, because that's the instrument that they took free and clear, and they sold it to investors, and we didn't get anything.